Good evening, this is John Milburn for LAWS12062. This is Alternative Dispute Resolution. We're into week 7 of Term 2, 2019. Thank you very much for joining us. We have 3 people online. Those of you who haven't joined the live sessions, please consider doing so. One of the advantages of having people join a live session is that it's much easier for me to make it interactive, which is my aim, rather than you simply listening to me. And when we have less than 5 or 6, it makes it difficult for me because, you know, I don't want to pick on Peter and Emma and Michael that have joined us tonight for the live session. So, but please do feel free to contribute. Gary's joined us as well. Thank you very much, Gary, for joining us. If you have any questions or comments, please ask and we'll proceed from there. Tonight, we're going to start the issues around, if you like, other alternative dispute resolution practices. And I sent out a news forum request today for you to consider a number of questions in relation to a wide range of alternative dispute resolution processes. So I do hope that you've seen that. And I do ask that each of you please consider the questions that I've raised with a view to providing some response. Now, that said, we haven't yet finished arbitration, so I'll kick off tonight in terms of arbitration. And if you have the Commercial Arbitration Act 2013 in front of you, on your screen, for example, I'd urge you to follow along and contribute in that sense. One of the techniques that I use when I'm actually a participant in online seminars is that I will take notes as I go. So because I use voice recognition, I'll cut the camera out, mute the microphone, and as I'm going, I'm dictating to myself my notes rather than typing. So that's the sort of thing that you can do for these sessions as well, if you wish. But it's useful if you follow the legislation as we proceed. So have a look at Section 5 of the Act, which deals with the extent of court intervention. And the aim of commercial arbitration is essentially that no court must intervene except so provided by this Act. So that's the overriding provision in Section 5 of the Act. And the Supreme Court does have certain functions though. So no court is to intervene except as provided by the Act. And it may be that the arbitration agreement or an agreement between the parties will provide that the district court, for example, has jurisdiction. Refer in that regard to Section 6 of the Act, which provides that the court for certain functions of arbitration assistance and supervision are referred to in various sections, and they're to be performed by the Supreme Court, but the district court does have jurisdiction in certain circumstances. So if you have a question at the end of the term that relates to arbitration, one of the things you may need to consider is the jurisdiction of a court to hear the matter, particularly given that Section 5 says no court is to intervene except where provided. So what are the hurdles that need to be overcome in that regard? And then if you determine that a court can intervene, then which court should intervene? And there's discussion about the Supreme Court, and I've just raised the issue of the District Court, which is also referred to in Section 6. So it is compatible then with an arbitration agreement for a party to make a request, or indeed during arbitral proceedings for a party to make a request for a court to provide an interim order in certain circumstances. Have a look at Section 9 of the Act in that regard. And what I might do is share the screen. I'm using Ostly at this stage, and hopefully you can see Ostly there. So if we now go to Section 9 of the Act, you'll see the commentary that I've just made, that it is not incompatible for an arbitration agreement for courts to be requested, for parties to request the intervention of courts. So an arbitrator may be challenged in some circumstances, but the circumstances are limited. And the circumstances might be regarded as if there is justifiable doubts as to a number of important things. So, for example, if you conclude that an arbitrator is not acting impartially or independently, or the arbitrator doesn't possess suitable qualifications, then they are the sorts of things that might be the subject of an application to a court, despite the existence of the arbitration procedure. Have a look at section 12 in that regard, which provides for the grounds of challenging the composition of an arbitral proceeding. So section 12, subsection 3, refers to impartiality, independence, or a failure to have appropriate qualifications as agreed to by the parties. And so essentially what we're saying there is that there is a challenge available if there is a real danger of bias on the of the person conducting the arbitration. When there's an allegation of failure to act or impossibility to act, it may be that it's based around an inability of an arbitrator, either in law or in fact, to perform the functions or fail without undue delay to proceed. So if we look at section 14 of the Act, it makes reference to that. A party may request in some circumstances then the court to intervene, and there's reference there to the court. So you would certainly need to consider section 14. And just as a reminder, and I'm sure that all of you know this by now, but you can look at cases that are referred to in these various sections generally by looking to the note-up references in the right-hand corner. In this instance, there are none, but generally speaking, the note-up function is a great way for citation. In practice, if I have a situation like I've just shown there, where there are no note-up references or cases in OSLI, I'll usually go to JADE, but you can also go to Westlaw, LexisNexis, or other citators to find out relevant cases. If not, you can always look at textbooks or articles. The next section that I want to bring to your attention is section 16 of the Act. And section 16 talks about the competence of arbitral tribunals to rule on its own jurisdiction. So here we have that interesting preliminary question of whether, when there's a challenge to the jurisdiction of the arbitral tribunal, can it make its own ruling, or should it refer to an independent body, such as a court, to make that ruling? And section 16 says that an arbitral tribunal may rule on its own jurisdiction, which includes any objections with respect to the existence or validity of the arbitration agreement. So if the arbitral tribunal rules effectively as a preliminary question of law that it does have jurisdiction, then bear in mind that a party may seek to challenge that by giving 30 days notice of referral of the decision to a court. And in that regard, look at subsection 9 of the Act. If the arbitral tribunal rules that it does have jurisdiction, any party may request within 30 days of receiving that notice the court to decide the matter. So essentially, the effect of section 16 is to provide the arbitral tribunal with a jurisdiction at first instance, subject to a review, as outlined in section 16.9. The arbitral proceedings may allow for interim measures, and these interim measures, which are usually the role of courts to implement, can be significant. If we go to the next section, you'll see section 17. And it says that arbitrators or an arbitral tribunal may, at the request of a party, grant interim measures. Now, these are interim measures of considerable significance. And if you look at subsection 2, you'll see the definition, which provides that the arbitral tribunal may make an order to maintain or restore status quo, take action that would prevent or refrain from taking action that is likely to cause imminent harm or prejudice to the process, provide a means of preserving assets out of which a subsequent award may be satisfied, and preserve evidence that may be relevant and material to the resolution of the dispute. Now, I'm going to stop there and emphasise this point because it's significant. Section 17 of the Act is a section that provides a considerable degree of power on an arbitral tribunal to go beyond making a ruling about its own jurisdiction to hear the matter and make highly significant interim orders. I will ask generally, we've got 4 people, sorry, so that's good enough. Someone might be able to come up with some answers here. But can you look at section 17, subsection 2C, which talks about the ability of the arbitral tribunal to make an interim measure to provide a means of preserving assets out of which a subsequent award may be satisfied. Can anyone tell me what that looks like in terms of civil procedure or by reference to the Uniform Civil Procedure Rules? I'll be more broad. Is it, would you say that in essence, the Act could be rewritten or read as, meaning that the power to provide for an interim measure is the power of the arbitral tribunal to make or grant an injunction? Do you know what I mean by an injunction? Does it go that far? What do you think?
I think it does.
Yes, Peter?
I think it does. It
does
go that far, yeah.
Yep. Okay. And I'd agree with you there. Does anyone take a contrary view? It is essentially an injunction. It's a very powerful one. Does anyone know what we mean by an injunction that provides for the means of preserving assets? Also known as freezing orders and search orders when you look at D and C. Okay, so what I'm going to ask you to do is cross-reference your reading here to look at the Uniform Civil Procedure Rules, firstly, 260, which deals with freezing orders or Moravia orders. Have you heard of, has anyone done civil procedure? Very good, so you know what I mean by this. So Moravia orders provide for a court to make a freezing order to prevent the frustration of the court process by seeking to meet a danger that a judgment or prospective judgment may be wholly or partly unsatisfied. So if you look at 260A, it's very similar, isn't it, to that which is referred to in 17 2C and D. So search orders, have a look at UCPR 261A. Does anyone know the other name for a search order? I've already said the alternate name for a freezing order is a Moravia order. What's the other name for a search order? The particular type of injunction that allows a party to undertake a search against the will, if you like, of the opponent party. All right, so you'll need to do some research on this. It's an Anton Pillar order. Okay, so 261A of the Uniform Civil Procedure Rules deals with search orders, in other words, Anton Pillar orders, and it provides that a court can make an order which is called a search order for the purpose of securing or preserving evidence, and requiring people to permit others to enter premises for the sake of securing that material. And it's usually done in conjunction with strict undertakings. So when you're considering this, and I'll go back to sharing the screen now, to the Commercial Arbitration Act, I would like you to carefully consider Section 17. Consider what are the conditions for the granting of interim measures. Consider what is involved in the exercise of discretion. Consider whether there's a need for security. I mentioned in these matters that there is usually a need for security. And you'll see there that the Arbitral Tribunal in subsection 3 has the ability to make orders in relation to a number of things. Now, if we look at the table of provisions for the Act, you'll see that section 17 is in fact the subject of 10 subsections in addition to the main subsection, and covers all of Part 4A. So Part 4A was introduced, and section 17 and 17A through J inclusive deals with that issue. So that would be an area that you'd want to pay careful attention to, I think, as you progress through your studies. Are there any questions? Any comments? All good? All right. Have a look at section 17CAA, or section 17 rather, which has been omitted, sorry. So do have a look at those provisions that are applicable to applications for interim orders, and you will see the requirement for arbitral tribunals to receive certain information, which is subsection F, and there are issues in terms of costs and damages, which is to do with the undertaking that I mentioned. All right, if we move on, the next section is section 18, and there's a general statement here that parties are to be treated equally and given a reasonable opportunity to present their case. Whilst that section looks very simple and almost benign and obvious, it's the sort of section that you can use if you wish to challenge impartiality, in that the argument would be that the arbiter is not impartial because the party has not been given a reasonable opportunity of presenting the case, and it goes beyond what's merely stated in the common law and principles of natural justice to have statutory force behind it. So section 18 is important in that regard. Have a look at section 19, which deals with issues around determination of rules of procedure, and bearing in mind that the parties are free to agree on the procedures to be followed, but if there's no agreement, the tribunal, the arbitral tribunal, may conduct the arbitration in such a manner as it considers appropriate. That's the sort of provision we see in a lot of statutes that give rise to powers to tribunals around Australia. The next section to consider is section 21, and that deals with commencement of arbitral proceedings. And it provides that, I'll just share the screen here. Unless otherwise agreed by the parties, the procedures, or proceedings rather, in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. And you'll note that with many of these sections, there's reference to the model law and the article of the model law from which the section has been drawn. So in this instance, it's model law, Article 21. And you'll see that with all of the sections. So roughly the section in the Act corresponds with the section in the model law. There are some procedural steps in terms of nominating someone who is a suitably qualified person. And if you don't, then the arbitration is void. So for a case, have a look at Oakland against Benaim. That's OAKLAND against BENAIM, 1953 2QB, which is Queen's Bench English, 261. It was a case about estoppel. Another question that arises is, can an arbitrator delegate powers to have a different person undertake the arbitration or do some of the work that's required? So the general rule is that any such thing would only occur if authorised by the agreement between the parties, but ultimately the arbitrator must come up with his or her own opinion, even though there may be some power for deferral of some of the work elsewhere. Now, when it comes to the arbitrator's powers, bear in mind something we have looked at briefly, and that is section 19, subsection 3. I'll share the screen again to the Commercial Arbitration Act. And 19 subsection 3 says, the power conferred on an arbitral tribunal includes the power to determine the admissibility, relevance, materiality and weight of any evidence. Generally, the arbitration provides that the arbitrator is not bound by the rules of evidence, but the arbitrator must still adhere to rules of procedural fairness. And the arbitrator does have power to order disclosure, to make orders, as we've talked about, and they can be quite wide-reaching. Some of the wide-reaching powers of an arbitrator are, for example, an arbitrator can make an order to dissolve the partnership. An arbitrator can grant equitable relief, and the arbitrator can decide matters on the papers. It's very wide-reaching potentially. Another issue is adjournments, and arbitrators can only adjourn if natural justice dictates it's appropriate to do so, and the arbitrator must consider the parties and allow the parties to present their case. Generally speaking, the procedures are adversarial, meaning there's cross-examination. Well, I'm doing a lot of talking. Are there any questions? No? Good. You know, if you don't ask questions, it only encourages me to keep going. All right, let's do that. So, why do you think that a court could ever set aside an arbitrator's award? We know what's an award for an arbitrator? It's the decision, isn't it? Can a court ever set aside the decision of the arbitrator? Let's assume the answer to that is yes. Thank you, Michael. What would be some of the bases upon which a court might consider doing that?
Wouldn't be just like normal judicial reviews of error of law?
Yes. Yes. An error of law, yep. Probably,
Not
yes,
impartial?
what's that, sorry?
Hearing not being impartial?
Yes, yes, I agree with that. A procedural one, like a preliminary one, is that the arbitral tribunal didn't have jurisdiction, or the award is too wide, or it's privileged, or some other basis. So a case that you might want to look at, which is fairly recent, is Mango Boulevard, and I'll share the reference to this case. So this is Mango Boulevard against Mio Art, 2018, QCA 39. And in that case, there was an argument about setting aside the arbitral award on the ground that the arbitrator failed to afford the appellant procedural fairness. So some of Michael, Peter, the comments you made earlier apply in that type of situation. Now, procedural fairness is not an express ground to set aside an arbitral award under Section 34 of the Act, but it may engage the grounds that a party was unable to put their case fairly, or the award was in conflict with public policy. So this case is useful in that it gives a clear indication as to how the courts can become involved in dealing with arbitral awards, some of the considerations that the court would need to consider in that regard, and some of the bases upon which the court might do so. Now, the court referred to Section 34 of the Commercial Arbitration Act, and if we look at Section 34, it deals with recourse against an award. So it deals with the issue of application for setting aside as exclusive recourse against an arbitral award, and so Section 34 would be relevant in that regard, in that discussion. The decision that you might want to consider in that case is that of Justice McMurdo. All right, so if we go back to the Act, share the screen, I'd ask you to now look at Section 21 of the Act. 21 deals with the commencement of proceedings. And then Section 22 have a look at Part 5, which deals with the conduct of arbitral proceedings generally. And you'll see that there's specific issues about the way in which the process is to be undertaken. Section 18 provides for equal treatment of parties, and we've discussed that. 19 deals with the rules of procedure, and 20, a mechanical provision about the place for determining the matter. If you go down to Section 27E, and so 27 we were talking about earlier about court's assistance, you'll see the disclosure of confidential information, where parties must not disclose confidential information in relation to arbitral proceedings unless there are certain circumstances. Now, this provision reverses the previous position as it was in Esso against Plowman, 1995, 183 CLR 10, where the High Court concluded that whilst the privacy of arbitral proceedings should be respected, confidentiality was not an essential attribute. So previously, the trend of Australian courts was to diminish or at least question the confidentiality of arbitral proceedings, particularly those proceedings where there was a public interest. All right, so have a look at Section 34 of the Act also, and that section is relevant in terms of questions of law that might arise, and we've discussed that briefly. And just coming back to that Mango Boulevard and Mio Art decision, if we look at paragraph 20 of the decision, there's a key statement. And I'm sorry, so this is a bit out of order, but if we look at paragraph 20 of the decision, and I'll refer to it now, I'll put it on the screen. If I can find it, sorry. There we go. Paragraph 20 is relevant in that Justice Jackson adopted the words of the Chief Justice of Singapore in the decision of AKN and sorry, I'm just looking at the section paragraph 20. It's just not coming up the way I'd wanted to. Sorry, my apologies. Just pan down. No. All right, no, it's not. It's just not working for me. I'm sorry. So what I will do is ask you to look for this in the Mango Boulevard and Mio Art decision. There's a statement by Justice Jackson, and in that section of the case, he refers to a judgment of the Singapore Court of Appeal in the case of AKN against ALC. And what it does is provide a brief statement of the rights of appeal from arbitral awards with a statement that courts can't always, the courts can't ever intervene. They can, but it talks about the fact that they narrowly do so in only certain circumstances. So it's a good quote, and I will try to find that. So I'm sorry I wasn't able to identify that quote at the moment. When you're preparing your study, also consider some of the advantages and disadvantages of arbitration as opposed to court proceedings. And a good reference point, a good resource is this organisation's website, which is the Australian Centre for International Commercial Arbitration, which provides information that would assist you from a practical perspective. And this organisation, the Australian Centre for International Commercial Arbitration, you'll see is not for profit. It's to promote and facilitate efficient resolution of commercial disputes. And it is the default authority under the International Arbitration Act, Commonwealth. Another thing that you might consider is family arbitration. Have a look at the Family Law Act, 1975, and the Family Law Regulations, 1984. Have a look at Section 10M of the Family Law Act, which provides for the definition of an arbitrator, and look at Regulation 67B, which works in with that section. All right, well, that might do us then for arbitration. Thank you for your patience as I work through that. Any questions on arbitration? Any comments? All good? Okay. Well, let's move on to other areas then, if you like, other dispute resolution processes. We'll start with collaborative law. Can anyone tell me what we mean by collaborative law? Where did it begin? What are the characteristics? What area of practice is known for collaborative law? Any thoughts? Yes, Peter?
Family law.
Absolutely, yes. And has anyone come across any, in their research, any collaborative law firms, for example?
Nope.
In past assessments, I've actually got people to make contact with practitioners, not just in collaborative law, but in different areas. So one thing you could consider doing as part of your research is investigating websites for those firms that actually practice in collaborative law, in family law, and maybe even speaking to some of the practitioners to get a feel for what it's like. So in the material that I've asked you to consider for preparing for this week, you should know the answers to: where did collaborative law begin? What is the definition? What are the characteristics? What are the steps in collaborative law process? What dispute areas use collaborative law? And what do we make of it? Do we need it? Does it serve a purpose? Does it help the lawyers rather than the participants? As a cynical comment. The sort of questions that you might be asked in an examination, you know, in terms of please critically comment upon, that sort of thing. All right, so that's collaborative law. And we'll come back to that. Just looking at some of the others, dispute resolution advisor. So the questions that I asked you to consider this week are: where did the concept begin? What is the object of appointing a dispute resolution advisor? What's the process that the dispute resolution advisor will adopt? And can you contrast that for me between the role of a dispute resolution advisor and an appraiser or referee? So this week, the work is fairly detailed in that you've got to work through these issues yourself, and it's almost as if you need flowcharts or lists. Comparative tables, for example, might work for your study, so that you're identifying the similarities, the differences, identifying how these processes begin, how they actually work in practice, for example. The next one is in relation to dispute review boards. And you need to go beyond seeing that there's a name for these things, but again, where did they begin is always a good way to understand what they mean. What are the operations? Are the decisions made by dispute review boards final and binding? To what extent have they been used in Australia in a practical sense? Partnering, what is the operation of partnering? Who are the stakeholders in partnering? And then we get to this tricky area of appraisals, evaluations, and determinations. And sometimes the names are a little misleading. So when you think of an appraisal or an evaluation or determination, you need to be able to describe the operations. Again, are they binding, not binding? How do they relate to case appraisal? What are the differences? What are the similarities? And then we need court-appointed referees. Why would a court choose to reference out as we describe it? Is the court bound by the decision of the referee? What is the legislative basis for the appointment of a referee? Adjudication. In what type of dispute do we see adjudicators? What's the legislative basis for appointing an adjudicator? What powers do adjudicators have to conduct proceedings? Has anyone come across any adjudication? Aware of what bodies provide adjudication, decision-making processes?
Building and Construction Services Payments Act, 2004.
BSIPA, yes. That's the one that immediately comes to my mind. So if I was providing you, if I was looking to answer a question for an examination around adjudication, I would agree with what Peter has said there in terms of the type of work. Next one, dispute resolution and criminal justice system. What does restorative justice mean? How does it work in practice? Can anyone tell me what we mean by restorative justice? What area of law does it relate to? Any thoughts? All right, so.
It's criminal law.
Criminal law, exactly. Yes, yes, it is. All right. I've conducted restorative justice mediations, and I've acted for parties in restorative justice mediations. So it's a developing area. It still hasn't taken on a great deal yet. All right. So for all the purposes of your assessment, can I say this? That over the years that I've been taking this unit, at various times, I've included specific questions that relate to other areas of dispute resolution practice, and they might be specific areas that relate to dispute resolution boards or partnering or restorative justice. So you may get that type of question for your examination. And they're reasonably straightforward. More difficult is the type of question that I sometimes ask where I present a scenario and indicate that I would like you to determine in advance for people that are going into a commercial arrangement, for example, what is the best way to structure their dispute resolution requirements. Is it going to be arbitration? Is it going to be through early neutral evaluation or determination, whatever it might be, and then justify your decision? So you can't answer a question like that unless you first have a clear understanding of what these things mean and what they do. So in asking you to prepare for this week's work, I have consistently said, where did this concept begin? Because if you understand where it began, it's a bit like the mischief rule in statutory interpretation. We get an idea of how it came to be and what it was intended to solve. So that might help you in terms of working backwards to work on what is an appropriate way to resolve a dispute. So from a practical perspective, the exam could be one of two types. If it's a problem-based exam, it might be, here we have some people that want to set up a system that will work for them. What are the options and what do you recommend? The other type of exam question is, things have gone badly. How can we use ADR processes to resolve them? I hope that makes sense. All right. In terms of the platforms, you need to understand these different platforms, and as I mentioned, have some way of providing an answer to yourself as to how they work in practice. There's a few good articles in the reading this week that might assist you. So let's look at the first of the problem-solving type questions, and that is, if you're called upon by me to develop a dispute resolution or dispute prevention process, one of the two. Where do we start? If you are presented with a scenario and the question is, well, please develop a dispute prevention process or a dispute resolution process, what do you do? What are the things that you need to consider? Any thoughts?
First thing you'd need to do is look at the dispute and the parties involved in that dispute.
Yes, get a feel for their particular
yeah.
circumstances. That makes sense.
And a lot of the answers will come from that.
Yes. And it depends on the nature of the dispute, doesn't it? As you mentioned earlier, if it's a matter involving building dispute, then you might be thinking more in terms of adjudication or possibly arbitration, for example. But there are great opportunities for dispute review boards and other partnering even in commercial building disputes as well. You need to then consider what's in the textbook. Now, we'll have a quick comment about collaborative law. Peter mentioned correctly that it's based around family law typically. It doesn't have to be just family law, but that's where it's mostly used. So in collaborative law practice, first thing I'd ask you to do is get a feel for where it is on the overall continuum. So that means referring you back to page 3 of your text and that simple continuum. And you'll see that collaborative law is number 8 out of 14. So it's mid-level in terms of whether it's informal, consensual, as opposed to formal and non-consensual and interventionalist. So in terms of collaborative law, the process is led by lawyers, and it's not mediation, but it looks a little like mediation in the sense that the lawyers are attempting to resolve the matter for their clients outside of court. And the commitment that they make is, if we can't resolve this out of court, we're not going to court. We're not going to court. So as lawyers, we're precluding ourselves. So it provides for, if you like, a degree of comfort that these lawyers will assist the parties as best they can to get it resolved without the matter going to court. So there's a lot to be said for that. It's, if you like, another way of stating this might be, it's almost like mediation without a mediator. Now, having said that, and you've got 2 mediators, one representing each of the parties. Having said that, the parties could, through their lawyers, arrange for the collaborative law process to incorporate mediation. So the two are not mutually exclusive. But collaboration commences, if you like, as an informal conference, a roundtable discussion, but with a twist, as in the lawyers won't go to court. It's more formal than mediation, and it does take the dispute a little away from the parties beyond mediation, but a way of restoring some power to the parties in this process is to allow for a mediation to be built in to the collaboration process. So if you look at NADRAC, the definition of collaboration is where the process is led by lawyers representing each of the participants, where it is agreed that the lawyers will cease to act for their client if the matter proceeds to litigation. And that's the key. The lawyers are saying, we're not going to get involved in litigation. So it has characteristics where there is a cooperative and to some degree non-adversarial manner and approach. I like collaboration because it seems to me it's adopting a common sense approach to resolving the issue. And it also provides for the parties' lawyers to not only provide a degree of advocacy without being necessarily adversarial, but also to provide them with a coaching ability and to encourage the parties to come to a resolution. Now, of course, all of this is voluntary and it requires full disclosure. It's not going to work if one of the parties is trying to hide information from the other. So here are the 7 basic steps, if you like, for collaborative law. So number 1, identify the interests of the parties. Number 2, identify the questions that need to be answered. Number 3, gather information. Number 4, generate choices. Number 5, evaluate options and maybe modify or refine them. Number 6 is negotiate an acceptable agreement, and number 7 is to close. So they're the kind of 7 key steps for collaborative law practice. And Spencer, in your textbook, page 171 of the current edition, talks about the fact that family law was the basis upon which collaborative law commenced, and he refers to it being used to great effect in North America in resolving certain disputes. And it's been described as a paradigm shift from adversarial to cooperative practice, from lawyer-directed and rights-based negotiations to client-centered interest-based collaboration. But Spencer also makes the comment, and I think quite rightly, that it can work in a commercial sphere and it can work in general civil disputes. So what do we make of collaborative law then? So Spencer says it's a paradigm shift, and I think that's right. You might wonder whether it does take the dispute away from the lawyer and give it to the parties to some degree. I think it possibly does. But did you notice those steps that I referred to are very similar to the steps in the process in mediation, aren't they? Where you're trying to identify issues, you're trying to find out appropriate facts and generate choices and evaluate various options that are available. So collaborative law, I think, can certainly have real benefits to the parties. But the question is, can you identify what those benefits are to the parties for me? So you don't have to answer that now, but I will ask, are there any questions? Because I might wrap it up fairly soon. And I'm sorry that I'm doing all the talking. It's not my aim. Now, Gary says, what about communication, Gary? You can unmute your microphone if you like. Yep.
Yeah, John, I was just saying, in a situation like that where you have two lawyers, two parties, no mediator, doesn't that sort of like close the lines of communication between the parties themselves, especially in a family law matter?
That's a very good point. Arguably, though, whenever parties engage lawyers, and this is not meant to be an anti-lawyer comment, but whenever parties engage lawyers, it's always open to that risk. I think that lawyers who embrace ADR encourage, for example, mediation, or maybe work within collaborative law and incorporate mediation into that process, are the sort of lawyers that are going to encourage the parties to retain ownership of their own dispute and to become engaged. But I think you're right, there's very much a risk that engaging lawyers in any sense will take the dispute away from the parties to some degree. Does that answer your question, Gary?
Yeah, I think so, John. I just think it's really important that the two parties, especially in a family law situation, need to openly communicate respectfully, because if they don't, they can't see the other person's side through the other person's eyes. And I just think that when they're represented by lawyers, they sort of like sit back and let the lawyers do their jousting for them. If I'm sort of like coming from the right, left of field.
Yes, look, I agree with what you're saying. There's a very good journal article by Arda and Coombs. It's called The Legal Profession Post, ADR, From Mediation to Collaborative Law, and it's 2007, 18 Australasian Dispute Resolution Journal 205. And in that, the authors describe collaborative law as a process without mediators, but it serves some similarity. And it talks about having 4 to 7 collaborative law sessions as a typical regime. So in each one of those sessions, ideally, the lawyers are with their client and the other side in an informal discussion regime, so that there is an active discussion and involvement. It's not merely delegating the task to the lawyers. So I think that there are some benefits to the parties in that regard.
John, when I first read that about the collaborative process, I was quite horrified, really, that the fact that the lawyers were going to sort of disbar themselves from going to litigation if that was the case, and also the allied professionals as well. But the more you start thinking about it, it's really quite a common sense approach with it. And because there is that disbarment from litigation, they're really going to sort of, the lawyers being involved and being able to advise their clients and, to accept something that is that a client may not be quite as inclined to accept is probably not a bad thing.
Yes, and no, that's a very good observation, Peter. And it's almost counterintuitive for lawyers, because typically those of us that have been around for a while, we were trained to go to court. So everything was geared around, perhaps you might send a letter of demand, but then you issue proceedings. And the problem is that then once the court process starts, without the ADR built in, it becomes like parallel tracks of a train line, where both parties are working towards the train station, if you like, on different tracks, but they're not meeting at any stage. So collaborative law provides that commitment from the lawyers to join up and discuss matters straight away. And the incentive is, if you can't resolve this amicably to some degree amongst yourselves, then you have to hand over the file. So lawyers have got a big incentive to try and make it work.
John, doesn't that put undue pressure on the parties to maybe accept an agreement that they don't really want to accept?
Good point, but bear in mind that the session it's not a single session, so it goes over a period of time, and you work on the assumption that both lawyers are competent, experienced, and can provide good advice. Yes, there's pressure, but the idea is that instead of having a $100,000 bill and lots of regrets for both parties, way down the track, the parties can try to work through the sessions themselves with the lawyers.
The other thing that I can see it working with, particularly in family law, is you often get a situation where they're so intransient in their beliefs, the participants, that mediation without the assistance of lawyers is not going to help them at all, because they're just so tunnel visioned about what they want out of that situation that they're not prepared to give an inch, whereas a lawyer is more open to ideas. They've got a better understanding of how the system works and what is acceptable and what is not acceptable in the long term. And I mean, it for people, this would work in many cases where otherwise it would go to litigation.
I agree with that. And the lawyers can provide a degree of objectivity that might be sorely missing, particularly in the early days from the parties.
But doesn't that come back to also the skills of the mediator, especially as a lot of mediators are lawyers?
Yeah, well, true. But of course, in collaborative law, you don't necessarily have mediators, so and very often you don't. So the lawyers are in that situation are taking a funny role where they're almost mediating, but they're not quite. They're still advocating, but they're doing so with a kind of a collaborative law approach and a collaborative law level of thinking.
A mediator can't sit there and say, okay, you silly twerp, this is the best deal you're going to possibly get. Take it, for heaven's sakes. Whereas the lawyers can sit back and do that.
That's a really good point, and that's an excellent point. And again, this can still be done in conjunction with a mediation session. But you're right, Peter. The lawyers can be and should, in many circumstances, be quite direct in their advice, very clear in their advice. Excellent. All right. Well, we might wrap it up there. Thank you so much for your participation.
John, did you see the article I posted on Moodle concerning that movie?
Was it this afternoon?
No, about a week or so ago.
Oh, sorry. No.
It was the movie called The Best of Enemies. I'm not sure if anyone's seen it. And it deals with a situation and true life story in the early 1970s where the town of Durham in North Carolina, they had a charrette, which to me, the way I was thinking of it, was actually a huge mediation session. And it turned out that the two opposing sides were so far apart. In fact, one was a black woman and the other person was one of the hierarchy of the KKK. And the whole movie is a true story, and the outcome at the end is a credit to mediation. And it's readily available. It's called The Best of Enemies. And if you want to have a look at probably an early version of mediation or whatever you want to call it, it's well worth sitting down for an hour and a half and watching this movie, and especially that it's a true story.
Right, thanks for the commendation. I'll keep an eye out for that for sure, Gary. So sorry I hadn't raised that earlier. Excellent. Well, thank you very much for that contribution, and for all of you. Next week, we'll continue with our discussion, and we'll start with dispute resolution advisors. So please have a look at those questions that I raised in the news forum today, and prepare ready for us for next week. All the best, and we'll see you.
Bye, John.
Bye then, Peter. Bye, everyone.
Bye, Gary.